We simply cannot allow people to pour into the United States undetected, undocumented, unchecked.
And complete the dang fence.
This bill that we will sign today is not a revolutionary bill.
Cast down your bucket where you are.
We come from France.
And I am, adamantly against illegal immigrants.
They're coming in by the thousands, just unbelievable.
The wall is an immorality.
Who are you rooting for?
Those masters of the universe are at it again.
You maniac! You blew it up!
Welcome to Parsing Immigration Policy, the podcast of the Center for Immigration Studies. My name is Mark Krikorian, Executive Director of the Center, and we're going to talk this week about something the President just announced this week, a de facto amnesty for estimated more than 500,000 illegal immigrants in the United States. And to discuss what this is and what the implications are and what have you, we have with us our frequent guest, Andrew Arthur, Art Arthur, who has been writing on these issues for us for many years, is deeply familiar with both the legislative and the executive and the judicial aspects of immigration. And this particular amnesty sort of involves or is connected to all of that. So thanks for joining us, Art. And if you could just start by just the basic outline on what it is the President announced this week and, some of the specifics, and then we'll get into more detail.
Sure, and thank you for having me, Mark. Under the proposal that President Biden put out on June the 18th, some 500,000 alien spouses of United States citizens who are here illegally will be eligible to apply for something called parole in place, which is a variety of parole that Congress has given, parole authority that Congress has given the executive branch under Section 212D5A of the Immigration and Nationality Act. What parole basically does is it allows a foreign national who is not admissible to the United States to enter, or in this case, remain in the United States in a quasi-legal status. Now, in order to take advantage of this, the alien spouse had to have been in this country for at least 10 years unlawfully and had to have married a United States citizen on or before June the 17th, 2024. In addition to that estimated 500,000 alien spouses who would qualify under this provision, it would also allow up to an estimated 50,000 children of those alien spouses to apply for parole in place as well, provided again that their alien parent was here illegally for 10 years as of the date. Now, those kids don't need to have been here for 10 years. They could have shown up on June the 17th to been a witness at their parents' wedding. But so long as the parent qualifies, they are going to qualify as well.
So let's discuss a little bit about what this parole thing means, because we've talked about this before, but the administration has used this limited, narrow power of parole at the border a lot and at airports too. And that's a whole other issue. But parole in place was a completely fictitious, made up thing by the executive until Congress, I think the Republicans were asleep at the switch, and Nancy Pelosi in 2020 got a reference to it in statute. And so now magically it's a real thing. But even then, if you could explain how it was limited and how parole in place basically is kind of retroactively paroling people into the country when parole is supposed to be something used at the border or at an airport for very specific, narrow, temporary purposes.
Sure. And, just to go back very briefly, the parole statute itself limits the executive branch's ability to allow a foreign national who is inadmissible to the United States to enter the country without being formally admitted. The parole statute delineates the restrictions on that authority. Section 212D5A of the INA says that the Secretary can parole inadmissible aliens into the United States, but, quote, only on a case-by-case basis for urgent humanitarian reasons or significant public benefit, close quote. And the parole authority is limited to aliens who are applying for admission to the United States, which goes to the nature of parole itself. Traditionally, classically, parole, which Congress first created in the Immigration and Nationality Act of 1952, was meant for aliens who showed up at a U.S. port of entry. There was something wrong with their documents, and they weren't therefore admissible to the United States, or they had some status that barred their admission. And notwithstanding those defects, the port office or the district director or the then Attorney General of the United States could allow that individual to temporarily come into the country. Now, again, remember that this can only be granted for urgent humanitarian reasons or significant public benefit. Traditionally, urgent humanitarian reasons have meant that the alien, again at the port of entry, needs emergency medical care. And significant public benefit has long been interpreted to mean that we need that particular alien to appear either as a witness or as a defendant at an ongoing criminal trial in the United States. Now, there's some question as to whether when Congress created the single removal system in 1996 that it expanded that parole authority to aliens who come illegally to the United States. And I think that that is still an open question and that arguments could be made on either side. But notwithstanding all of that, back under the Clinton administration, a group of lawyers got together and determined that they could use that parole authority to allow classes of aliens who were in the United States to remain here in a quasi-legal parole status. That was the genesis of parole in place. Now, between the time that the Clinton administration crafted this plan and 2019, there really wasn't any legislative gloss that was added to parole in place. In the National Defense Authorization Act of 2020, a group of Democratic members got together and decided that parole in place should be applied to a very select group of individuals. And those are the spouses and stepchildren of United States servicemen, that those people shouldn't be forced to leave the United States, but that they could be allowed to remain and seek proper immigration status using that parole in place authority. But again, even under NDAA 2020, which is how we refer to it, parole in place is only for immediate relatives of active duty servicemen. It's not for classes of 500,000 or more aliens who are here illegally in the United States who are related to somebody who's not in the military. So that's just the first of the issues with this. And I anticipate that the various issues with this plan are going to be fully vetted and resolved in the courts in coming months.
So actually, just to give a little more context here, a lot of people will assume that if you're an illegal alien and you marry a U.S. citizen, and it's legitimate, it's not a fraudulent thing, that you're okay, that you'll be able to resolve your status. The problem is that there's a provision in the law that says if you've been here illegally for a certain period of time, that you have to leave and are barred from re-entering. So that, in other words, the issue that this parole in place kind of retroactive parole grant the administration is using is a way of getting around what's called the 3-year, 10-year bar. If you could just briefly explain why it is that a sympathetic group, really, of illegal immigrants who are married to U.S. citizens, why they can't just kind of adjust their status is the terminology. Why can't they just do that anyway? What's the administration's explanation for why something like this is needed?
Sure. And to do that very briefly, I just want to note the fact that the rule today and the rule for as long as we've had immigration laws have been that when foreign nationals want to come to the United States, they consular process abroad. They go to a U.S. consulate in their home country or a nearby country or any country they want, and they, apply for the visa that will allow them to come to the United States. Now, For decades, Congress has permitted aliens who are lawfully in the United States, who have been either admitted or, importantly, paroled into this country, to adjust their status, which you've just described. And adjustment of status is basically a legal fiction where we pretend that you went to a consulate abroad, but instead of the State Department giving you that visa, it is the Department of Homeland Security that's giving you that visa and then allowing you, without ever showing up at a port of entry, to receive that visa in the course of the adjustment process. And as an immigration judge, as an immigration prosecutor, I've done hundreds, if not thousands, of so-called adjustment cases. The problem in the case of, this 500,000 plus class of individuals is that in order to adjust your status, again, you had to have been admitted or paroled. These people entered illegally. They never went through the admission process. And up to this point, they'd never been paroled. But that's just the first problem. Any alien who is illegally present in the United States, unlawfully present is the term that the statute uses, for 180 days to 1 year are barred from entering the United States lawfully for 3 years. If they've been here for a year or more, they're barred from entering the United States lawfully for a period of 10 years. That's what you meant when you talked about the 3 and 10-year bars. So individuals who, would otherwise be barred from re-entering the United States, but who are the beneficiaries of immediate relative visas filed on their behalf by U.S. citizen spouses, already have a procedure that they can use to get around the 3 and 10-year bars. They can file what's called an I-601 waiver, which DHS usually dutifully approves, and that allows them to leave the United States, go to a consulate abroad, get their visa, and then re-enter, and we basically pretend like they weren't here for a period of years unlawfully. So that's in the law already. The problem is that most people don't go that route for a couple of reasons. One, because you actually have to apply, and as this class of individuals suggests, they're not big on complying with the legal immigration system generally. But two, they're afraid that if they leave the country, they're not going to be allowed back in. So that has definitely limited the utility of that I-601 waiver process generally. But, and this is an important but, USCIS drags its feet on actually adjudicating those applications. Again, most people who apply for one of these waivers of the 3 and 10-year bars gets it. But as of the end of FY 2023, a year in which USCIS adjudicated fewer than 13,000 I-601A waivers, there were 133,000 aliens plus in the queue to get one. So, the Biden administration is basically attempting to get around a problem it itself has created by slow walking all of those I-601 waivers. But, and again, we could talk more about the impacts that this is going to have, that this Biden plan is going to have on USCIS, but vouchsafe it to say that one of the biggest problems with the Biden illegal immigration schemes are that it makes it harder for people to get legal immigrant visas.
Yeah, I want to get to that point as well. But just as a question, you said that most of these waiver applications that would be able to deal with this issue anyway are approved. Are those numbers reported, or is that something, in other words, the percentage of waiver applications for immediate relatives, are those reported, or is that another thing we have to FOIA?
Yeah, no, that is something that is reported,
Okay.
and I could go back to the specific documents to get the exact percentages, but this is a commonly used system. It's one of those things that came into prevalence under the Obama administration that was never really stopped by the Trump administration, and that continues to this day.
Right. So just a couple of points on what this status offers people. So they're going to get parole. Basically, even this is a kind of legal fiction because they will be now imagined to have been let in legally. It kind of retroactively legalizes their illegal entry to the United States. And that allows them to, file the paperwork to get their green card. But it also comes with a work permit and a Social Security number. Isn't that correct?
Yeah, it does. So any individual who's paroled into the United States by regulation can apply for work authorization. And again, you have to apply, but most people do. And it is that work authorization program that the Biden administration, is facilitating for people who've been paroled into the United States that's gumming up the works at USCIS generally.
In other words, even before this announcement, it was gumming up the works at USCIS.
It was gumming up the works. And as soon as those individuals get work permits, they are then able to go to the Social Security Administration, show their work permit, and get a valid Social Security number. By the way, when we talk about most of these applications are approved, in FY 2023, there were 12,278 approvals and only 921 denials.
Right.
So, that'll give you an idea of, how many of these things are actually approved.
So that's well over a 90% approval rate for people seeking to fix this problem. In other words, of an illegal immigrant married to a U.S. citizen. In other words, this announcement, the way you put it in an earlier blog post from, I think, April, and we're going to link to it in the show notes, is that parole in place is a solution in search of a problem because the solution is already there for people who are in this position.
Yes, absolutely. And again, if you go through that waiver process, if you leave the United States and pick up your visa abroad, U.S. immigration law is perfectly happy to pretend you were never, here unlawfully, that you never committed all of the offenses that would have otherwise barred you from adjusting your status. So, yeah, this really is a solution in search of a problem. But, one of the things that the administration talks about is that, these poor folks, if they were forced to go abroad, would have to wait months and months to, actually come back into the country. That, again, is under the Biden administration's control. The Department of State can fast track those visa approvals abroad. They just haven't put the resources into doing it, which is an important point when considering the administration's claim that it is doing this to reunite American families. If it really wanted to reunite American families, it could take the 130,000 plus 601s that it's got, approve 90+% of them, and then facilitate visa processing at the consulates abroad and let those people come right back to the country.
Right, exactly. And a couple of things here, even though obviously illegal immigrants married to U.S. citizens, because of all the things we've described, are in a kind of pickle, as it were, there's no danger they're going to be getting deported, certainly not by this administration. And again, this is the issue of a solution in search of a problem. How many illegal immigrant spouses of U.S. citizens, at least those who weren't committing any especially heinous crime, because even if they committed regular crimes, they'd probably not be deported, how many of them are being deported anyway? So, there was no actual pressing policy need for this announcement that the White House made.
Yeah, no. And, it's important to note the fact that I've been involved in immigration enforcement to one degree or another since the George H.W. Bush administration. Alien spouses of United States citizens are the last group of aliens that are ever going to get deported from the United States, even if Donald Trump says he's going to have a mass deportation program. These folks are never going anywhere. You're going to go after the national security risks. You're going to go after the criminals. You're going to go after the unrelated recent arrivals. And then as you work your way down the list, the last people who are ever going to be removed are these spouses and their kids, for what that's worth. And especially under Biden administration guidance in guidelines that were issued in September 2021 by DHS Secretary Alejandro Mayorkas, the recently impeached DHS Secretary Alejandro Mayorkas, make it next to impossible that these people, unless they commit a really serious crime, are ever going anywhere.
Right. In fact, those guidelines, enforcement guidelines limiting what ICE is allowed to do, actually makes it hard for ICE agents even to question illegal immigrants unless they've already, they can prove they've already done something. So, so again, this reinforces the point that this week's amnesty announcement by the president was a solution in search of a problem. And I think I want to talk a little bit about why he might have done this. But before that, this is one more example of unilateral executive action based on dubious legal precedents in immigration. Obviously, we've seen it in other things too, student loans and what have you. But there actually is a legislative vehicle to address this specific issue that's been used in the past. The shorthand of it is 245I. And without a whole lecture on the issue, what could legislatively Congress have done to address this particular problem that the administration is saying that, needs to get fixed?
Sure. And, the fix for this is actually extremely simple. Congress could go in and they could wipe away the 3 and 10-year bars. They've only been in the law now for 28 years, which in immigration terms is practically yesterday. But if they were to do that, it would definitely facilitate the ability of these individuals to remain. More importantly, however, the legislative branch could extend the date for what's called 245I. It's important to note that up until April of 2000, aliens who were in this situation were nonetheless able to adjust their status under Section 245I of the Act. Now, Congress considered, pushing that date, even further forward, well into the new millennium back in 2001, but no action was taken on it because there was a lack of bipartisan agreement. Moreover, and this is probably more important and more to your point, when Democrats controlled both houses of Congress and the White House in the last Congress, they could have moved that 245I date up. They could have moved it to the date of enactment or, a year after the date of enactment, which would, more or less encompass all of these people. But the president was unwilling to engage in any sort of negotiations with Republicans in Congress who still had the ability to block a 245I change. Didn't want to trade off any asylum reforms, didn't want to trade off any border security improvements, didn't want to expand detention in order to grant benefits, in order to do what he claims he's doing now for this class of individuals. The law is clear and the law is easily amended. I could write this down in about 300 words. It would be a page and a half long, the bill. But of course, there would have to be some trade-off. The administration doesn't want to make legislative trade-offs, especially now that Republicans control the House of Representatives, which is why it does all of these things outside of that legal structure. It's also important to note, Mark, that there's not much that's settled in 500 years of Anglo-American law in what is now the United States. But the one thing that is firmly resettled, in fact, Congress has said it's embedded in the judicial and legislative tissues of the United States, is that Congress makes the rules about who's allowed to enter the country and who gets to stay. So, and it's because the Biden administration doesn't want to go to Capitol Hill, doesn't want to go to its friends, doesn't want to go to its political opponents and strike a deal that it can't get this done. I was a congressional staffer for 8 years. I could make a deal with anybody. Nobody's going to walk away happy, but you will have a solution that everybody more or less likes. But the Biden administration doesn't have the will or the intention to do that, which is why it keeps taking its limited powers and stretching them as wide as it possibly can until the courts step in and say no.
Yeah, I mean, that's the issue that we've seen with DACA as well, because the problem is not, for instance, in DACA, that they couldn't get a bill, an actual law passed by actual lawmakers that legalized people, illegal immigrants who came here especially at very young ages and grew up here. That's a sympathetic group of people, and even I'd be for something like that. But it would have to be part of a package, as you suggest, to try to address the problem that created a dreamer population to begin with. Otherwise, you're just mopping up the spill and not turning off the faucet. And like you suggested, the administration, whether it's in DACA, whether it's in this issue that they announced today of spouses of U.S. citizens, they have no interest whatsoever in engaging in the process, the legislative process of give and take, of compromise. And it's not just the administration. I mean, I don't think the Democratic leadership in Congress has any interest in it. And frankly, the Republican leadership would have a little bit of trouble getting anything that had that de facto amnestied people, but they would be able to, I think, get support for it. And in fact, during the Trump administration, the White House backed a plan that would have legalized a large number of people who came at young ages in exchange for other important enforcement and legal immigration fixes. And they got a lot of Republican votes for it. Most Republicans voted for it. Democrats didn't. And so it didn't go anywhere. So it seems to me this amnesty announcement of this week really does highlight a bigger problem, that the Democrats in particular are simply uninterested in any form of legislative compromise. Is that they either want everything, which is what the bill that the performative bill the White House introduced when President Biden first came into office and was acknowledged as dead on arrival by everybody. So they either want that, which is everything, or they're just going to, they're sort of just going to push their way through with executive edicts like this and hope for the best. And as Mickey Kaus, who's been a guest on this program before, a friend of the show, as they say, he pointed out on Twitter that 12 years after DACA was decreed by Obama, and that anniversary was recently, just a week or two ago, 12 years later, it's still in place, and it still hasn't formally, fully, officially been determined to be unlawful. So why wouldn't the Biden administration just try to do more of the same and see how much they can get away with?
So there are actually 3 points that I'd like to raise there. First is we know that the Obama administration did DACA, but before it did DACA, the Democrats held a supermajority in the Senate and had control of the House and the White House. They could have, just done DACA without any Republican votes. They could have done a massive amnesty without Republican votes, but, they didn't. The second point is that, when you talk about Donald Trump, and this is an important point, we think of him being, so hard when it comes to immigration. He was willing to agree to an amnesty of 1.8 million DACA recipients and other people who had been brought here as children. So, we're not talking about a small number of people.
Right.
And what he wanted in exchange was to move the country to more of a skills-based system consistent with our allies in Canada, the United Kingdom, Australia, New Zealand, other big immigrant receiving countries. But the third point is really the most important. Be it DACA or be it this plan, what these instances of executive branch overreach really do is they poison the well. Mm-hmm. There was an op-ed in the Wall Street Journal on June the 19th that, talked about this new parole in place program. And it said, Joe Biden is the worst president for legal immigration because it poisons the well. It just makes it all the harder for Republicans to subsequently agree to anything, because no matter what restrictions Republicans were to put in place at the border, the Biden administration has shown a willingness to just ignore them. You can't trade off with somebody if the thing that you get in the trade-off isn't actually going to mean anything. It's just going to be words on paper. And unfortunately, again, all of this has had a deleterious effect. We saw a poll from the economist YouGov just last week in which a plurality, more than 30% of respondents who were polled, referred to immigration as a bad thing for the United States. Of course, you and I and the center generally support legal immigration and, legal and properly controlled immigration. But when you turn the American people off against immigration, that's a problem that could be, intractable for a number of years. And, that's a bad thing. It's a bad thing no matter how you look at it.
The flip side, though, on this issue is that it may well be that you need something like the conduct of the Biden administration, both its profligate actions at the border as well as these kind of lawless actions. It may take that to create the political will to do something to actually fix the immigration system. I mean, I have no idea, we'll see, but, there's a saying in Russian, which I think is Чем хуже, тем лучше. The worse, the better. So in a kind of, I think it was Trotsky maybe who said that, in a Trotskyite sense, it may actually be necessary for things to get as bad as they are for us to be able to get, basic common sense reforms through Congress. But one thing I wanted to bring up that we didn't touch on and about this, the consequences of this, and actually I think we need a shorthand term for it because, DACA obviously is nobody goes out and says deferred action for childhood arrivals all the time. The shorthand term for this seems to be PIP, parole in place. We should just call this the PIP program. One of the things you talked about in a blog post about it that you published this week is the opportunities for fraud. And obviously, as fraud is a real possibility in any kind of immigration program, even ones everybody supports. I mean, there's all kinds of fraud in the marriage category where people have fraudulent marriages. That's just sort of one of the things you got to deal with. But this has, kind of special vulnerabilities to fraud. And so I just wondered if we could just talk about that briefly before we wrap up.
Sure. I mean, first, there is the issue of marriage fraud. And, marriage fraud is a real thing. It's so common that there is a Gerard Depardieu, Andie MacDowell light comedy called Green Card that talks exactly about a foreign national who marries a woman so he can stay.
And he gets deported. He gets deported when they find out and then has to wait several years before he's allowed to come back.
Yeah, that really doesn't happen. But in any event, with respect to, the true fraud that's going to come out of this program is that 10-year requirement. So you're going to have, hundreds of thousands of people who are married to United States citizens who weren't here for 10 years on June 17, 2024. Those individuals are going to cobble together documents to show that, they actually were here. It's going to be rent receipts written on, a pad of paper that you buy at Staples tomorrow, or, a pay statement cranked out on a dot matrix printer, something like that, that's going to show that they've been here. And when you talk about 550,000 people, the ability of USCIS to adjudicate those cases to actually identify that fraud is going to be non-existent. Right now, or as of the end of the first quarter of 2024, FY 2024, there were 9 million pending cases at USCIS. Add on to that another 550,000 cases and consider the fact that USCIS is a fee-funded agency. It's basically pay as you go, where you hire people based on the receipts that you have. They're never going to be able to do anything to ferret out that fraud. I actually think the 550,000 figure is going to be low when all of this is done. This is going to be very similar to the SAW program, the 1986 agricultural worker amnesty that was just rife with fraud. And, again, there's going to be nothing that we can do about it.
Right.
And, simply based on the scope and the bandwidth of USCIS, we're going to have to accept the fraud unless, of course, this program isn't struck down.
Which, I think the administration is happy to accept the fraud. The only downside is that the fraud won't be as colorful as it was during the farm worker part of the 1986 amnesty, where the people claiming to have been farm workers, were asked questions like, what did you pick? And they said, well, it was watermelons. I worked in a watermelon farm. And they said, well, did you pick the watermelons from the trees? And they said, yeah, trees. We got up on ladders and picked the watermelons from the watermelon trees. And, harvesting purple cotton and digging cherries out of the ground. I mean, there's all kinds of ludicrous lies because there were people who just didn't have the vaguest idea. So the fraud in this PIP program the president announced is going to be maybe as widespread, we'll see, but unfortunately it won't be quite as colorful and memorable. So the only thing I wanted to wrap up on, and this is sort of not a legal or administrative question, but put a different hat on now, Art, why would the president announce this now? Clearly it's a political measure, and it seems to me whether or not it actually survives in the court, they see themselves as winning either way. In other words, if it's upheld, then, they get to legalize more illegal aliens. And if it's struck down, they get to say, look, the terrible courts have stopped me from doing this wonderful thing.
Sure. And, that's a pretty straightforward answer because on the one hand, you're probably going, if you're the Biden administration, you're going to get the goodwill of that 500,000 population of U.S. citizens who are married to these alien spouses. And, that's if it's not struck down, if nobody challenges it, or if Texas tries to challenge it and their case is dismissed. But if Texas or Florida or any other state goes to court and challenges this thing and it does get enjoined or struck down, then the Democrats can turn and they can look at the Republicans, be it Ted Cruz in Texas or Rick Scott in Florida or whoever else, and say, those people want to separate families. If they didn't want to separate families, they would have stopped the local AG from suing over this. So this is a win-win for the Biden administration. And it gets to the key point, sort of interesting that this is the first time we discussed it. This is a purely political act. And it's not coincidental that this was done nearly 12 years to the day after Barack Obama, facing re-election in 2012, did exactly the same thing with DACA.
And the interesting thing is, I've actually spoken with people, this is secondhand because the people in the White House, in the Obama White House, would not have told me this, but that the reason they did DACA is because they looked at the Hispanic registration numbers for the 2012 reelection, and they were way down, and they were actually worried. They were looking for some way to goose turnout. And the Biden reelection campaign is, if anything, in even deeper trouble with Hispanics. And so it's pretty clearly a campaign measure. I'm skeptical it's going to make any difference because all it's going to do really is reinforce the idea that he's the anti-Trump when it comes to immigration and controlling the border. But, they may know what they're doing. The one thing you just referred to, but we haven't seen any news on this, is a lawsuit challenging it. I saw a tweet by Governor Abbott of Texas who said this is unlawful or something like that. But so I assume Texas will sue. Will they even be able to get the time of day in court? I don't want a whole legal analysis here, but could this just, be thrown out because the states don't have standing to sue to stop this?
The states, especially Texas, plainly will have standing because it loses, I think, $95 for every driver's license that it issues. And all of those spouses and all of the kids who are old enough to drive are then going to be able to go to the Texas DMV and get driver's licenses, which is going to impose a cost. And it could be $1 of cost. It's generally much larger than that. But $1 of cost is enough to actually get you standing. And Texas is in the Fifth Circuit, and Fifth Circuit law is very favorable as it comes to states obtaining standing to challenge immigration policy.
Interesting. Okay. And the fact is the administration just a few weeks ago announced supposedly cracking down at the border, which is a whole other issue. It's, as you've written, it's basically their new policy is smoke and mirrors. I mean, the numbers have gone down some, but it's almost certainly just a wait and see result, and their smugglers are going to find a way around it pretty quickly. But the ACLU said it was going to sue to stop that. I haven't heard any details on that, but the interesting thing would be if the administration issues this supposedly tough rule and then follows it up with this amnesty rule, they both end up being, held up in court. And I mean, I expect the White House would be fine with that. In fact, is almost looking forward to having all of these measures be frozen by courts so that they don't have any actual consequences in the real world, but they can use them for political purposes. So with that, we'll wrap it up. We'll almost certainly have you back, Art, probably to talk about some of this consequence or something else when there's more litigation about this or some resolution to the litigation. So in the meantime, thanks for joining us, Art, and keep up the good work.
Thank you, Mark.
So that's it for this week's episode of Parsing Immigration Policy. This is Mark Krikorian, your host. I want to thank Brian Griffith, our producer, and thank all of you for tuning in, and hope you will join us on our next episode.